Hello, Beth.
Hello, Ed.
How are you?
Good. How about you?
Just fine. Hello, Alex.
Evening.
Good evening, Graham.
Evening.
All right, so we currently have attendees in the room. We're just gonna wait a couple minutes to get started officially here.
Maggie just said that we're on. I think we're on camera, right? For everybody? Great.
We are at 7 p.m., but we'll give people another few minutes to pop on here. We'll get started very shortly. Okay, I think we'll get started at this point. We want to allow plenty of time for questions from the public. So I'm just going to go through a brief introduction. Good evening, and thank you all for getting on tonight to participate in the Township's Affordable Housing Information Session. Tonight, we have 3 of the Township's professionals that will present on the Township's affordable housing history, current settlement agreement, but most of all be available to the members of the public who wish to ask questions on the topic. Tonight's session is being recorded and will be posted on the Township's website tomorrow. For those who are not familiar, I am going to just show you that the Township does have a section of the website set up for this purpose of the affordable housing page. We also want to make everybody aware that, and I'm just having a technical issue there, but that it's located under our community on our homepage, has FAQs and other information regarding affordable housing. We will have a question and answer period and anticipate that we'll be able to get to everyone's questions. We just ask that those participating limit their initial interaction to questions and do so within a 3-minute time frame to ensure that we can reach everybody. Our professionals will wait until all of your questions have been asked, and upon your conclusion, we'll answer. We ask that participants do their best not to repeat questions that have already been asked and answered. If time allows, we will come back to anyone that wishes to make a comment or a statement on this topic. If we do run out of time, which I do not anticipate at this time, but the session, we will ask those individuals who wish to ask additional questions or have an additional comment or statement to email us at letusknow@milburntwp.org. While professionals will be presenting tonight on this content, I would just like to recognize that there are members of our Township Committee that are on listening and to the presentation and to all of your questions. These include Mayor Miggins, Deputy Mayor Eglow, Committeewoman Prupus, Committeeman Wasserman. Finally, I'd like to introduce our presenters tonight. Ed Buzak, who is on as a presenter, is the Township's Special Counsel on Affordable Housing. Graham Petto is from the Township's planning firm, Topology. And Beth McManus, who is the Township's Special Planner on Affordable Housing Matters. With that, I am going to turn it over to Ed Buzak, who is going to be presenting first.
Thank you, Alice. Good evening, everybody. I'd just like to say at the outset that we will not be addressing the 100% affordable project this evening. We're in the process of discussing issues related to that project with the Special Master and Fair Share Housing Center. And this will be deferred to a second presentation that will be devoted solely to that project. I was tasked with the assignment of going through the history of Mount Laurel and telling us why we are where we are or how we got to where we are. Little did anyone know in May of 1972, when Judge Martino found the system of land use regulation in the township of Mount Laurel unlawfully excluded low and moderate income families from the township, that he had sown the seeds for an affordable housing doctrine that endures today, and that municipalities have been struggling with for now going on 5 decades. That 1972 trial court case by Judge Martino resulted in the 1975 Supreme Court case known as Mount Laurel 1, which established definitively the constitutional precept that the ability to zone that was held by municipalities derived from the New Jersey Constitution and was delegated by the legislature to municipalities, carried with it the constitutional obligation to promote the public health, safety, morals, and the general welfare. Specifically, the Supreme Court found that the proper provision in zoning ordinances for adequate housing for all categories of people is an essential element in promoting the general welfare, and thereby established the original Mount Laurel doctrine, or what we know today as the Mount Laurel doctrine. That doctrine declared that every developing municipality must, by its land use regulations, presumptively make realistically possible an appropriate variety and choice of housing, and must affirmatively afford that opportunity, at least to the extent of the municipality's fair share of the present and prospective regional need unless the municipality was able to demonstrate some kind of peculiar circumstance that would eliminate its obligation to do so, or which would reduce its obligation to do so. 8 years later, in 1983, a different Supreme Court, led by Chief Justice Willens and 3 other new justices, charted a new course for dealing with exclusionary zoning in what's known as Mount Laurel II. While keeping true to the basic tenet, the Supreme Court refined the doctrine to incorporate the then existing State Development Guide Plan, and held that those municipalities within the growth area as set forth on the concept map of the State Development Guide Plan or any official revision were subject to the prospective need obligation of Mount Laurel that I just referred to. Therefore, the land use regulations of those municipalities, those developing municipalities as identified in the State Development Guide Plan, were constitutionally required to provide a realistic opportunity for the construction of a fair share of the region's low and moderate income housing needs. Those municipalities that had no portion of their land within the growth area would still be required to provide a realistic opportunity for decent housing for at least some part of its residents currently occupying dilapidated or substandard housing. The court went on in Mount Laurel II to establish a very elaborate and detailed procedure to implement the doctrine. The implementation procedure involved the appointment of 3 judges selected by the Chief Justice with the approval of the Supreme Court itself, who would handle all of the Mount Laurel cases in the state, dividing the state into 3 regions: Northern Region, Central Region, and Southern Region. Because the same judge would be hearing and deciding all Mount Laurel cases within their particular area, it was thought that over a period of time, a consistent pattern would emerge, as would a consistent formula establishing the obligations and the compliance mechanisms. Importantly, in Mount Laurel II, the court also endorsed the concept of a builder's remedy for those builders who acted in good faith and attempted to vindicate the constitutional right and the constitutional obligation of the low and moderate income households on whose behalf those builder remedy lawsuits were brought. The carrot that the Supreme Court gave to the builders was that if they brought the lawsuit challenging the validity of the zoning ordinance of a municipality, contending that it was constitutionally deficient, and were successful, their property would be able to benefit by rezoning it with a higher density in an inclusionary way, that is, providing a set aside but increasing substantially the density, absent some other unusual circumstances of that particular property. So effectively, the court co-opted the building industry to advance this constitutional obligation because they felt that between 1975 and 1983, there really had been no significant effort on behalf of the municipalities to voluntarily or affirmatively assume the constitutional obligation that the Supreme Court had identified in 1975. There's a couple of quotes that I'd like to just read from Mount Laurel II because they're important to see where the court was at that time and how they viewed the future, how they viewed the landscape coming forward. They said, for example, quote, "We reassure all concerned that Mount Laurel is not designed to sweep away all land use restrictions or leave our open spaces and natural resources prey to speculators." Unquote. The Supreme Court also said, quote, "No one community need be concerned that it will be radically transformed by a deluge of low and moderate income developments, nor should any community conclude that its residents will move to other suburbs as a result of this decision. For those other suburbs may well be required to do their part to provide the same housing. Finally, once a community has satisfied its fair share obligation, the Mount Laurel Doctrine will not restrict other measures, including large lot and open area zoning, that would maintain its beauty and communal character. Almost 40 years later, we're still debating this issue as to whether what the vision of this future landscape is. Some opponents of affordable housing and Mount Laurel Doctrine have blamed suburban sprawl on Mount Laurel. Proponents of Mount Laurel argue that sprawl was created by the massive amount of market housing built in the last decades and not by the affordable units that were required to be constructed. Actually, both positions have some seeds of truth. Some observers are of the view that the implementation of the Mount Laurel Doctrine to the builder's remedy and mandatory set-asides did in fact radically transform many communities in this state, and that Mount Laurel did leave our open space and natural resources prey to speculators. So there's been great debate over the last several decades over this entire matter. The Supreme Court, both in 1975 and more pointedly in 1983, however, recognized that judicial action in this area of affordable housing had its drawbacks. They said, quote, "A brief reminder of the judicial role in this sensitive area is appropriate, since powerful reasons suggest, and we agree, that the matter is better left to the legislature. We act first and foremost because the Constitution of our state requires protection of the interests involved and because the legislature has not protected them. We recognize the social and economic controversy and its political consequences that has resulted in relatively little legislative action in the field. But enforcement of constitutional rights cannot await a supporting political consensus. So while we have always preferred legislative to judicial action in this field, we shall continue until the legislature acts to do our best to uphold the constitutional obligation that underlies the Mount Laurel Doctrine. That is our duty. We may not build houses, but we do enforce the Constitution," unquote. So that was the overall overarching view that the Supreme Court had in 1983 after Mount Laurel 1 and Mount Laurel 2. In 1985, the legislature heeded the call of the judiciary by adopting the Fair Housing Act. The constitutionality of that legislation was almost immediately brought before the Supreme Court in what's known as Mount Laurel 3, and the Supreme Court found the act was constitutional and applauded the legislature for picking up the gauntlet that it had laid down in Mount Laurel 1 and Mount Laurel 2. The Fair Housing Act created the Council on Affordable Housing, known affectionately as COA, as the administrative agency to deal with all aspects of the Mount Laurel Doctrine. The obligations would be aided by now a new plan called the State Development and Redevelopment Plan, which replaced the State Development Guide Plan that I referred to earlier in Mount Laurel 2 that existed in 1983. This State Development and Redevelopment Plan derived from the newly formed State Planning Commission pursuant to a 1985 legislative act. In 2002, the Supreme Court dealt with other Mount Laurel issues in a trilogy of cases. Generally speaking, they're not given Mount Laurel significance in that sense. They're not known as Mount Laurel 4, 5, and 6. But they were a trilogy of cases in which the court continued to uphold the Fair Housing Act and further continued to defer to COA as the administrative agency that had been designated by the legislature to undertake these functions. After the Fair Housing Act was adopted and COA was created, over the period between 1987 and 1999, COA went through 2 rounds, so to speak, of calculating affordable housing obligations for all of the municipalities in the state. The obligations were based upon a complicated formula of speculative projected statewide and regional population, economic, and employment growth, which was then translated into affordable housing needs. Those affordable housing needs were then allocated to individual municipalities according to various criteria, including land availability, employment growth, development growth, and income of residents. Since municipalities first had to produce a plan to show how they were going to be realistically creating the opportunity to satisfy their obligation, critics have long complained that the system instigated sprawl and growth as opposed to responding to the needs created by market forces. Opponents to that methodology have characterized it as the field of dreams philosophy. Build it and they will come. While the Fair Housing Act and COA did provide a municipality with the opportunity to control its own destiny by giving them the choice from a menu of compliance mechanisms, the formula utilized through 1987 through 1999 gave municipalities no control over its future obligations. Those obligations were established by the state through the COA process that I've just referred to. In 1999, there was a determination made by COA that they should re-examine the methodology that they had been utilizing in the past. And after a series of information sessions and stakeholder sessions and so forth, COA in late 2003, they're typically known as the 2004 regulations, substituted a completely different methodology than that had been used previously. The methodology that COA proposed in late 2003 and early 2004 was known as the growth share philosophy. It still required municipalities to satisfy their prior obligations and their existing substandard housing occupied by low and moderate income households. But it established the prospective need in a different way. And COA itself summarized the growth share concept as follows, quote, "The growth share component was determined by projecting future affordable statewide and regional housing need and subtracting secondary sources of supply. The resulting net or growth share is expressed as a ratio of obligatory affordable housing units to all housing units built, and as a ratio of obligatory affordable housing units to all newly created jobs." Essentially what they did was they said in the first iteration of these third round rules that it was going to be a build as you grow methodology. And that methodology at the time when first proposed created a ratio that 1 in every 10 housing units that were built in a municipality would have to be an affordable unit. So there would be 9 market units and 1 affordable unit. And with regard to jobs, at the time, the initial proposal was that there would be 1 affordable housing unit obligation created for every 30 jobs that were created by non-residential growth in a municipality. And those jobs were established again under a formula that COA had tied to jobs per square foot and other things. It wasn't a perfect formula by any means, but it was attempting to create a sort of a parallel growth. So as a municipality grew, its affordable housing obligations would be established and satisfied. Those regulations, they were proposed in late 2003, adopted in 2004, and they were immediately challenged by Fair Share Housing Center. In 2007, and those are challenged directly to the appellate division. That's the process that is established for challenging regulations of governmental entities in the state of New Jersey, administrative agencies in the state of New Jersey. In 2007, the appellate division invalidated the regulations and sent them back to COA and gave them a deadline to establish revised regulations. They did not invalidate, however, this growth share concept. They found the growth share concept generically was an acceptable method, but they had a number of issues with regard to the manner in which that was established. COA went back, created what's known today as the second iteration of the third round regulations, in which they attempted to address the issues that the appellate division had articulated in their opinion. Those regulations were then challenged. And in fact, those were challenged not only by Fair Share, but were also challenged by the League of Municipalities. I had the opportunity to represent the League in that case, and that was the first time that the League had ever challenged COA regulations as an entity. So effectively, COA offended everybody. No one was left satisfied with what COA had done. That case also went to the appellate division and was interestingly decided by Judge Skillman, who was one of the three original Mount Laurel judges that the Supreme Court appointed in 1983 for Central New Jersey to handle these cases. So he was not unfamiliar with this whole concept of Mount Laurel, which was a good thing. He did invalidate the regulations, but in a comment in his opinion, he invited the Supreme Court and said, in so many words, this may be a good time for the Supreme Court to take this case and figure out what we're going to do here. And indeed, that is what happened. Petitions for certification were filed, the Supreme Court took the case. And in 2013, the Supreme Court, in reviewing the methodology, determined that growth share was invalid. That process, that methodology, the underlying concept that a municipality, as it grew, would provide affordable housing in parallel with its growth, was not a workable or constitutional methodology, and directed COA to go back and establish a methodology that was based much more closely on the methodology used in the first round and second round regulations. COA did that. They had some deadlines, they missed some deadlines, but ultimately they proposed regulations. There were comments submitted to the regulations. And in 2014, I believe it was in October, COA met to now consider these regulations that it had proposed and consider the comments that had been made. At that meeting, absolutely surprisingly to everyone, COA deadlocked. The vote, as I recall, was a 3-3 vote, and they promptly adjourned the meeting, never having adopted the regulations, and of course, passing shortly after that, the deadline passed for COA to have adopted it based upon the Supreme Court ruling. That then prompted Fair Share to bring a motion before the Supreme Court to enforce litigants' rights, and in 2015, early the next year, the Supreme Court stripped COA of jurisdiction of the cases that had been pending before it. At that time, there were over 300 petitions for certification, which was the administrative process that municipalities who wanted to voluntarily participate in the program and satisfy their constitutional obligation and get the imprimatur of COA through a process or through a result known as a determination of substantive certification. Over 300 municipalities were pending, the petitions were pending before COA at that time. And the Supreme Court, after stripping COA of its jurisdiction, saying essentially it was a non-functioning entity, gave all of those municipalities, and frankly, all municipalities, a window of opportunity to bring what's known as a declaratory judgment action in their in the courts in the counties in which they were located. So we're going back to 3 judges and 3 regions and so forth. These were going to be brought in the county in which the municipality was located. That window of opportunity existed. I think it was a 90-day or 120-day window where municipalities were, if they wanted to participate, they could file their declaratory judgment actions. Over 300 municipalities did that. Not all of those that were before COA did it. There were some new ones who did it as well. And that then started the process of where we are now. Milburn had not been before COA at that time, and indeed was not before COA at any time in the prior two rounds. However, in 2018 and earlier, I guess in 2017 and early 2018, a housing element and fair share plan was prepared, which is part of the master plan. It was approved by the planning board. It was endorsed by the township committee at the time, and the township committee authorized the filing of a declaratory judgment action in 2018, in April of 2018. That is the declaratory judgment action, which was the subject of the settlement that is now being implemented and about which this session tonight is about. With that, Alice, I'm going to turn it back to you. I got us to where we are now, and I'm going to leave it to Beth and Graham to show where we went from there. Thank you.
Thanks, Ed. Beth and Graham?
Yeah, folks, I'm going to start things, and Alex, if you don't mind, I'm going to share my screen. Here we go. I hope folks can see that. So what I'm going to do is I'm going to start talking about the settlement agreement that Fair Share Housing Center, or that the township entered into with Fair Share Housing Center. And so with that, let's first start with what are the pieces of the puzzle? What are the parts of the obligation that Milburn is responsible for satisfying? And there are two broad categories, and then they are broken down from there. The first broad category is referred to as the rehabilitation obligation, sometimes also referred to as the present need. And that is an estimated number of substandard units that are occupied by low and moderate income households. And these are units that already exist within Millburn Township. It's as stated, it's simply an estimate based on data sources like the census or the American Community Survey. And so that's one category and one component of the obligation. The second category is referred to as the new construction obligation. And these new construction obligations are the number of new affordable housing units that need to be created, and they reflect the individual rounds of affordable housing that Mr. Buzak just went through. The first round, the second round, and now we're here in the third round. And so this new construction obligation is broken down into the prior round obligation, and that's the cumulative sum of the first and second rounds. And then we have that third round obligation, which reflects the current obligation. And that's for the third round, which goes from 1999 all the way through 2025. And so as we look at these individual components of the obligation, the next, I think, obvious question is, well, what is Milburn's obligation? And so as you can see here, we have our rehabilitation obligation set at 109 units. We also have our prior round obligation, again, that cumulative first and second round obligation at 261 units. And then our third round obligation of that 26-year period of 1,115 housing units. And as I'm going to talk about a little bit later, there are some adjustments to this prior and third round obligation that have a dramatic impact on the number of new units that Milburn needs to provide. But before we get into that, let's just touch base about what the township is obligated to do for the rehabilitation obligation. And so, as I said first, that is 109 units. And there are three components or three terms that are relevant to this obligation in our settlement agreement. The first one is the fact that the township has the option of doing a survey that's called a structural condition survey. And that would be essentially a windshield, a drive-through survey that municipal staff would do to see if that 109 unit obligation is eligible to be reduced. That is an option that Milburn may exercise. And it's unclear whether we'll proceed with that at that time. We don't need to decide just yet. But regardless of whether it's 109 units or some reduced number, there are two programs that the township needs to do to meet that obligation. The first one is just to simply participate in the existing Essex County Home Rehabilitation Program. So simply allow for units that are eligible for rehabilitation, whose homeowners apply to the county program, allow for those homeowners to participate in the program and for the township to take credit for any completed rehabilitations. And then the second component is to create a municipal rehabilitation program, and that would be to serve renter occupied households. And the reason why we have these two parts of meeting the rehabilitation obligation is that the obligation has to be, or excuse me, the program rehabilitation has to be open to not only owner occupied households, but also renter occupied households. And unfortunately, Essex County, like all counties, their program is not open to renter occupied households. And so the municipality has to supplement that. And the last thing to know about the rehabilitation obligation is that what's required is that the municipality make the program available for that number of units, the number of units that is the obligation. So right now, for 109 units, the municipality is not obligated to make 109 households participate. We simply need to make the program available so that 109 households can participate. And so again, for the rehab, all we have to do is participate in the county program and operate a supplemental municipal program for renter occupied households. And that would close out the rehabilitation obligation. So the next thing I want to talk about is, quite frankly, the more important obligation, and that is the new construction obligation. Now, as I said, it's broken down into the prior round and the third round. But the other thing that's important to understand about this new construction obligation, regardless of whether we're talking about the prior round obligation or the third round obligation, and regardless of what number of units that obligation is, there are a number of subcomponents that go into that. And I don't want to get into the weeds of all the details that you can see on the
Hold on,
slide.
Beth. You just cut out.
Can you hear me?
Can you just check your?
Is this better? Can you hear me?
Yes.
Okay, thank you. Sorry about that. What's important to know, rather than, because I'm not going to go through the weeds and all the details about the obligation, what's important to know is there are a variety of some subcomponents the municipality must address. It includes things such as 25% of those new construction units have to be rental units. Also, we have to have at least half of our affordable housing units, meaning the prior and the third round, being available to families, meaning they can't be restricted to seniors, they can't be restricted to those with special needs, for example. We also need a diverse income distribution. We need to include very low-income households, as well as moderate income households. And then lastly, we need to ensure that the affordable units provide a variety of bedroom sizes or unit sizes, meaning we need 1-bedroom units, 2-bedroom units, and 3-bedroom units. All of these individual components are necessary. We must meet each individual component if we're going to satisfy our obligation. So it goes above and beyond simply what is the total number of units needed. And so let's talk, now that we've gone through this, let's talk about exactly what Milburn is going to do to meet that prior and third round obligation. The first thing to know is that Milburn simply doesn't have enough land to meet that 261 unit prior round obligation or that 1,115 third round obligation. As everybody knows and feels as you live or drive through Milburn, we really just don't have that much vacant land. So fortunately, the affordable housing rules in New Jersey anticipate such a circumstance, and they have built right into those rules in Milburn something called a vacant land adjustment. And what that means is that the municipality is able to adjust downward its prior round and our third round obligation to reflect a number that is consistent with the amount of vacant and developable land in the municipality. And what's important to know is vacant and developable land is a specifically defined term in the affordable housing rules. It's not as simple as stating what land is simply undeveloped. There are a variety of other factors that need to be considered. The result of the exercise of looking at all the vacant and developable land, determining the capacity for development, and then determining the affordable housing set aside that could result. The result of this exercise are two numbers. The first one is referred to in this slide as the RDP, and that stands for Realistic Development Potential. The second number is the unmet need. In Millburn Township, our vacant land adjustment resulted in a 114 unit RDP, our downwardly adjusted number. The remaining obligation is referred to as the unmet need, and that's quite simply the mathematical difference between the total obligation and the RDP, and that resulting number is, of course, 1,262 units. Now, each of these obligations come with differing requirements. And so, as I said, here in Milburn, our RDP is 114 units. And that means that Millburn Township needs to create or identify sites that will be developed during the third round, enough that it creates 114 affordable housing units minus the amount of bonus credits. There are certain family rental units, for example, that are eligible for 2 credits instead of just simply 1 credit. And so the township is obligated to create sites that create a realistic opportunity for being developed between now and the end of the third round to meet that RDP, that realistic development potential. That remaining obligation, the unmet need, the municipality simply needs to create overlay zoning and other affordable housing strategies that are deemed adequate to contribute towards that obligation. So there is no requirement that Milburn create enough affordable housing units to meet the entirety of that unmet need. Instead, simply the municipality needs to look at its land development map, look at its zoning, and find what opportunities for affordable housing, for inclusionary housing could arise should overlay zoning or other zoning controls be put in place. And so our settlement agreement does just that. We identify a number of sites that we'll go through tonight that meet our RDP, and then we identify a number of other sites, largely including overlay zoning, to meet our unmet need. What's important to understand is in our settlement agreement, while we're seeking to meet our unmet need to create enough strategies to adequately contribute to that unmet need, the municipality sought to reduce density and sought to reduce overlay zoning to the extent necessary. And as a result, what we have is really a hybrid approach to meet our unmet need. And Graham is going to go through the details of this in just a minute. But what you see is a hybrid approach of overlay zoning, of zoning in place to simply by right zoning, if you will, conventional zoning, and also a 100% affordable housing project. And all of these projects were considered together as a way to create adequate opportunities to meet that unmet need. And so let's talk a little bit before we get into the details. What strategy did Millburn Township follow to satisfy our affordable housing obligation? So first and foremost, to meet that RDP, we wanted to use credits from approved projects, and we wanted to utilize all of our available bonus credits. So simply put, what strategies can we put in place that don't require additional developments? And so using those existing projects, using those bonus credits. The township also looked through its tax rolls to determine group homes, to utilize existing special needs housing that exists within the municipality. And then the last strategy to meet that RDP is settling with our developers that came to the table during our affordable housing process to utilize their sites. And the strategies for the unmet need, As I said before, the township sought to first and foremost reduce development in the township to the extent possible and to exclude rezoning and zoning changes within its residential districts. And so one of the things you'll notice is the township has made use of its non-residential districts in order to meet its unmet need. And then the last strategy, which is not site specific, but is required of any municipality receiving a vacant land adjustment, is a mandatory set aside ordinance. And all that requires very simply is wherever the municipality issues an approval, whether it's a D variance approval or rezoning or even a future redevelopment plan, wherever such approvals include multifamily housing, the municipality is obligated to receive a 20% set aside or obligated to impose a 20% set aside on the developer. It has no effect on whether the municipality needs to issue an approval for, say, a use variance, but if they do, they are obligated to impose that affordable housing set aside in the amount of 20%. And so as you can see on this map, this highlights all of the township's affordable housing sites, excluding our group homes. And as you can see, the municipality has made use of its non-residential districts in order to meet that unmet need and as well as its RDP. And so with that, I'm going to turn things over to Graham to provide an overview of our affordable housing sites.
Thank
Graham?
you, Beth.
Mhm.
Thanks. We can get started on the next slide. Good evening, everyone. So I'll be talking through each of the sites that is contained within the settlement agreement. You can visit the township's website, as Mr. McDonald said at the top, and to read the settlement agreement, and each of these sites is indicated and listed within the agreement document. So starting here, the first is the Upton at Canoe, Brook, located over on JFK Parkway. This 3.6 acre site is just about finished with development and was approved for 200 total units, of which 30 have been deemed as affordable units. The site also is improved with a 250 room hotel and approved for 260,000 square feet of office space. Next slide, please. Next is the Silverman Group property development at 85 Woodland Avenue, located at the corner of Woodland and Chatham Road. This site plan approval was granted in May 2021, and the approval is for 62 total units, of which 12 will be affordable and 50 market rate units. This will satisfy a portion of the unit requirement in the settlement agreement. And here we have a colored site plan of the proposed development site. Again, this was approved in May of 2021. And here's a color rendering of the proposed development with, again, 12 affordable units. Next is the Wells Fargo site located in downtown Milburn. This 1.5 acre site was granted site plan approval in February 2021. The approval is for 53 total units, of which 8 will be deemed affordable in this development proposal. Again, there will also be 3,000 square feet of retail space at the site. Here's a photo, image of the site plan and building concept. Next, we have the Annie Says property at 249 Milburn Avenue. This just over 2 acre site, 2.18 acres, is identified in the settlement agreement to be developed with 150 total units. Of those 150 units, 30 will be deemed affordable units. And this is part of an overlay zone, and the affordable housing overlay zone stipulating the development parameters for the site has already been approved by ordinance at the Township Committee. Here's a layout, a proposed site plan of the development on that site. The Public Works site is identified in the settlement agreement for 100% affordable development, 75 total units. The Woodmont property site located over at JFK Parkway. This is part of the settlement agreement as well. The township must rezone the site and did so by ordinance adopting an affordable housing overlay zone for this site. The proposal here would include 195 total units. Of those, 39 would be deemed affordable. And this property also requires approval from the Board of Public Utilities and other watershed management groups for development of this site. Again, the ordinance for defining the overlay for the affordable housing regulations has been adopted by the Township Committee for this site. Next, we'll be talking through, these are the zone changes These are not necessarily site specific, but speak to zone changes as part of the settlement agreement. So first here is the conservation recreation zone, including the Canoe Country Club property. The settlement stipulates a creation of an overlay zone district, which would create supplemental regulations specific for this property, not across the conservation recreation zone, but specific for this site. And it would include a 20% affordable housing set aside and permit residential development of 8 dwelling units per acre at this site. Next is the B2 highway commercial zone over along Morris Turnpike. Again, this area would create an overlay zone district over these properties shown here, permitting residential development of 18 dwelling units per acre. Of all residential development that would occur on these properties, 20% must be set aside for affordable housing. Continuing with the V2 zone here along Milburn Avenue, again, another overlay zone district implementation. Here, the overlay zone would permit residential development of up to 40 dwelling units per acre. And of the residential development that's developed in these areas, 20% must be reserved for affordable housing. Next is the B4 zone, which largely constitutes downtown Milburn, the main commercial area. Here again, an overlay district would be instituted as part of the proposal set under the settlement agreement. This would permit residential development of 25 dwelling units per acre, and 20% of all new residential development, again, in this area would be reserved for affordable housing. Next is the CMO Zone District. Again, this is identified in the settlement to create an overlay zone district here in this area to permit residential development at a density of 18 dwelling units per acre. And of the development that would occur in this area, 20% of all new residential development would be reserved for affordable housing. Next is the OR1 zone. This is the property off JFK Parkway across from the Short Hills Mall, including the Hilton Hotel. Again, here an overlay zone district would be instituted over this property to permit residential development at 20 dwelling units per acre. And of all new residential development at this site, 20% again would be required to be reserved for affordable housing. Back to you, Beth.
Thanks, Fran. So folks, I'm just going to wrap things up with some next steps and what's going to be included in our housing plan. So I think the next step is certainly to have our settlement agreement with Fair Share Housing Center reviewed and approved by the court. And that takes place in what's referred to as a fairness hearing. And that is a hearing typical for any of these settlement agreements between a municipality and Fair Share Housing Center. The purpose is to ensure that the settlement agreement is fair and reasonable to low and moderate income households, essentially the class of people that the settlement agreement is intended to protect and to assist with. Once that fairness hearing is completed, the municipality will continue its work on that 100% affordable housing site. As Mr. Buzek said, we've got to table some discussion with that, but we are going to be required to continue to work on that site and do what's necessary to fulfill the intent of the settlement agreement. Next, and beginning now and through spring and perhaps early summer of this year, is going to be work on the municipality's housing element and fair share plan. I'm going to talk a little bit about what's included in that next, but what's important to know right now is that that is an element of the master plan, and that means that it is adopted by the planning board. It becomes part of the master plan once they take that action, and then it also needs to be endorsed by the governing body. And so essentially the municipal governing body will review and endorse it for submission to court, because the final step in this process is to have one more court hearing, and that's referred to as a compliance hearing, essentially where the court reviews and approves our housing element and fair share plan. Essentially the master plan element adopted by the planning board and all of the implementing ordinances and documents that help support that. We do that in front of the judge. We do that with coordination with not only Fair Share Housing Center, since they're a partner or a signatory to our settlement agreement, but we also do that with the assistance of the special master assigned to the case. And so what you may be wondering is in that housing element and fair share plan, and that it starts out with, or rather the first item on the list is a housing demographic and employment analysis, essentially describing the existing conditions, housing, employment, et cetera, conditions in the township. We also have to address probable future affordable housing stock. We have to talk about the lands that are appropriate for affordable housing. And then, of course, we need to talk about what the municipality's obligation is and how we're going to satisfy it. So all those mechanisms we've talked about tonight, starting with the rehabilitation obligation and ending with our unmet need strategies. And as I referenced before, there are a number of implementing documents. It includes things like a trust spending plan, identifying how the municipality will expend affordable housing development fees it collects. Also a variety of administrative documents, and affordable housing regulating ordinance, resolutions, approving the sites that have received planning board approval to date, operating manuals to ensure that the affordable units are administered properly, and a variety of additional documents. It's ultimately quite a large package that the court is tasked with reviewing and approving. And so as we put that document together, or these documents together, there will be additional opportunities for public input, such as I mentioned in a bare minimum, the planning board public hearing, but also as the municipality goes through and adopts the various documents that are supporting the housing element fair share plan. And so with that, I wanted to close the presentation for now and give space for questions, and thank you to everybody that's participating.
Thank you, Beth. I just want to quickly, before we get into the Q&A, and certainly there's some coming in on the Q&A chat, but I want to encourage those individuals to ask some of their really good questions in the session as well. First and foremost, just again, ask everybody that wishes to participate in the Q&A to raise your hand should you want to be put in the queue. That we ask you to keep your questions to 3 minutes, and that you keep your time to questions so that we can answer those questions. If time allows, we'll circle back to address comments or statements from individuals, but hope that we can use this session to further educate and understand the process that the township's been through, the settlement agreement that is before us, and that we're currently in the process of implementing. And so just ask that everybody keep on topic, and that your questions are related to this matter, and so that everybody that is participating can learn from this opportunity and get the information that they've come here to get. So with that, we are going to open this up to Q&A. I will call on the individual, ask you to allow you to speak, ask you to ask your questions. Once you are finished asking your questions, we'll remove your permission to speak, and the panelists will answer those questions. Again, just want to make sure that we're all being respectful in this. I know that this is can be a hot topic, and that this is really important subject for our municipality, and just ask that everybody be respectful of one another and of the presenters and the professionals here as we go through this. Again, this is a good opportunity for everyone to learn what's been going on and what we've been through and what we're going to be going through as a municipality in the future. First and foremost, Beth, I'm just going to ask that maybe you can just shed some light on exactly what, and maybe Graham as well, what an overlay zone is and what that means.
Yeah, that's a great question. I saw that pop up in some of the questions that were asked. So an overlay zoning is a type of zoning that applies to site or sites, and it is essentially an optional piece of zoning. It is from a zoning perspective, sometimes it is literally shown as an overlay, is a secondary zone district. And what it states is that the underlying zoning, in Milburn's case, the existing commercial zoning remains in place. However, there is an additional option, this overlay zoning, that allows for, in this case, inclusionary housing. So it means if you own property that is subject to an overlay, you can either use the existing commercial zoning, perhaps you're in, say, the B2 district and you want to develop a store, that's fine. But as an option, you can exercise the overlay inclusionary housing and instead develop the site consistent with the overlay zoning for that property. It does not allow for folks to pick and choose zoning standards from each zone district that they like to sort of mix and match and make a third option. You must either use the existing underlying commercial district, or you can use that overlay zoning, which is available as an option for development.
Great, thank you, Beth. So again, I just ask that anybody who is currently chatting in questions, that you raise your hand and ask those questions. We have some really good questions coming in through that. So let me just get to that. Participant list. Okay. First up, Deborah,
Hi, can you hear me?
we can.
Hi, Deborah Nevis, 65 Knollwood Road. I'm sorry I came in late. Beth, I don't know if you talked about what our vacant land adjustment is, what that number is. I think I had heard somewhere it's around 150. I'm not sure if that's correct, but I don't know if you want to answer that and then I ask my next question, or if I should just ask everything all together.
Deborah, just please ask everything, and then
Okay.
we'll allow everybody to answer the question.
So by my calculations, we're at 194 with everything that's been presented in terms of Woodmont, DPW, Annie says Wells Fargo, Upton. So I think we're over our vacant land adjustment. So what does that mean in terms of future development and what the township can say yes and no to if we have met this vacant land adjustment, if that makes sense, that question.
And I can take that if you'd like. So I'm not sure if I misheard you, but I think you might have suggested that the RDP, that realistic development potential, is 150. It's 114, so 114. So let me be very clear about that. It's 114 units. And then the second question, I think, was, as you're counting up the various sites that we've gone through, and I know you mentioned the DPW, it seems like we're over the RDP. So what does that mean? What can we start to say no to? So one thing I want to be clear about is our RDP is satisfied with sites that do not include the DPW, for example. So our RDP is met through the Canoe site, the Silverman group property on Woodland Road, also the Wells Fargo site, the Annie Says property, and then lastly, a couple of group homes that we have in the municipality, the DPW, the Woodmont site, and then all of the various overlay zones that Graham went through. Those are all for the unmet need. So the municipality has just met. We have 114 credits, including the bonus credits, to meet our 114 unit RDP. And then the rest of those sites are contributing towards our unmet need. So in terms of what can we say no to, the municipality doesn't have the ability to start eliminating sites or various zoning strategies. Instead, we're obligated to adopt whatever zoning might still be outstanding. So for example, those unmet need zones, the zoning hasn't yet been adopted. And if and when applications come before the planning board, applications that seek to utilize those sites, whether it's the Woodmont or an overlay zone in, say, the B2 district, the municipality is going to be obligated to review those applications just like it would any other application, meaning that it's got to implement the zoning, it's got to enforce the zoning, it's got to hear any variance applications consistent with the municipal land use law, as opposed to saying, you know what, we've actually met our RDP and we think we have enough unmet need strategies. So we're going to deny the application. So ultimately, the municipality has just met its RDP. We have adequate unmet need measures in place, and we're going to be required to implement the terms of the settlement agreement, including approvals for development, presuming, of course, those approvals meet the applicable ordinances, meet the municipal land use law, as may be necessary.
Thanks, Beth. Moving on. Mr. Cosgrove,
Hello, folks. Can you hear me?
we can.
Okay, very good. David Cosgrove, 99 Oakview. Alex, I have about 4 questions, so I'm gonna rattle them off pretty quick.
Sounds good.
I think they should be easy, but a couple of questions directed to Ms. McManus, which is, what other towns have you done this for? Meaning this exact type of work. And then my understanding is you've been a special master for Judge Gardner before. I'm interested in what towns you did that for, what towns were involved. I'm interested in why there's an $85,000 quote donation being made by our town. I'm interested in whether we can back out of the agreement. And I'm particularly interested in your comment that we would be allowed to speak before the planning board, because my experience with the planning board is that they don't allow residents to talk. So those are the 4 or 5 questions. Thank you.
Thank you, Dave.
Okay,
Go ahead,
let's see. So what other towns do I do this type of work with? I have a number of clients that I've helped settle affordable housing litigation. I can name a couple of them. It includes places like, let's see, Wayne Township, Milburn, well, obviously Milburn. Let's see, Flemington Borough, Ridgewood Village, working with Asbury Park, Borough of Franklin Lakes, Township of Greenwich, Township of Harrison, South Jersey, not Essex County, Borough of Little Silver, Township of Union in Hunterdon County, and a handful of other municipalities. So I've worked in a number of counties throughout the state. Also, I do also serve as special master. You're correct. I work in a number of municipalities, including, but not limited to Essex County. So I've done work in places as special master, such as, but not limited to, in Essex. Let's see, Borough of Roseland, South Orange Village, Borough of Caldwell, and then a number of other municipalities in other counties as well. Special master in approximately 40 municipalities at this time. In terms of the $85,000 donation to Fair Share Housing Center, that is a term that you see in just about all settlement agreements. Fair Share Housing Center typically seeks attorney fees as part of their settlement agreement. And I have to say, for additional detail on that, I think I'm going to punt to Mr. Buzak. And then let's see. What the next question was, is the municipality able to back out of the settlement agreement? I think I'm also going to punt that to Mr. Buzak, but let me just say, I don't recommend it. And then I think your last question was speaking before the planning board. Every planning board in the state is obligated to take public comment on development applications that it receives, take public questions as well as public comments. I'm not. I think I'll also defer that to Mr. Buzak, because I'm just recalling now that he is also the planning board attorney. So sorry about that, Ed, but I think I handed a couple questions to you regarding the fair share fees, backing out, and planning board comment.
Before Ed starts, also there was a question regarding the $85,000 in the settlement agreement, and I believe this was for legal fees, but maybe
Yes.
we can speak to that as well.
Yeah, I think I'm going to ask Ed to comment. Thank you.
Yes, thank you. Beth is correct. The $85,000 was a negotiated number. I've done a number of settlement agreements, and every one of them with Fair Share has an attorney's fee section or a contribution for affordable housing, depending upon how it's structured and the source of the funds. That's part of the settlement. Backing out of the agreement, this settlement agreement is no different than any other contract. This contract is binding on all parties to that contract. It's been signed. The authorizations have been filed with the court. And the only way that this agreement will be unwound is if Judge Gardner, in a fairness hearing, finds that the agreement is not fair and reasonable, does not protect the interests of the protected class, and does not approve the settlement agreement. There's a contingency in the settlement agreement that says the agreement is subject to the approval of the court. And the last item with regards to the planning board, Beth has accurately set forth the process. All development applications are required to be open to the public and public comment taken. She was referring earlier in her presentation to the Housing Element Fair Share Plan, which has to be adopted by the planning board. As she pointed out, the Housing Element Fair Share Plan is an element of the master plan. The municipal land use law requires that before there's an amendment to the master plan, there has to be a public hearing and public comment taken. So there will be, at that appropriate time, public comment taken by the planning board because the law so requires. I think those are the three, Beth, that you passed to me, and I have none to pass back to you.
Great. We'll move on to the next. Ms. Urso?
Hi. Good evening, Perry Urso. How are you? So I have a question. So my husband and I, we own 5 commercial properties within the B3 district. Can you tell me why the B3 was excluded from your overlay? And appears that the only benefit that we're going to be getting is saddling with a couple things. Increase of the school tax. Was there any type of study done regarding the impact of the schools? And what type of responsibility will the developers have for the increase that's going to be required for the school? Does the municipality currently believe that the township's schools can sustain your overlays and the increase of your developments? So, one, why was the B3 excluded in your overlays? Was there a study done regarding how the development increase would impact our schools? What responsibility are the developers' infrastructure going to have on our schools? I'm going to be saddled with this increase of school tax being excluded from your overlays with no benefit. And also I have the new special improvement district that we're also being saddled with a new assessment. So hopefully you can answer these questions.
Thank you, Ms. Urso. We'll take a stab at all of those. But anybody want to start?
Start. So in turn, the first question was simply, why was the B3 district excluded? And, you know, unfortunately, I've got to say, I really can't get into the details of why the B3 was excluded versus other districts being included. That really was subject to the details of our settlement agreement negotiations with Fair Share Housing Center. So we really can't reveal the details of those negotiations. I'm sorry, I don't think maybe somebody else can, but I don't think I'm going to be able to provide a satisfactory answer to that question. And some of the other questions are really in regards to the school impact. So first, was there a study done for the schools? And then I'm going to couple that with the other question is, can the schools sustain the increase in school children? So there was no study done with the schools. There was no school projection study done specifically as part of this settlement agreement. And that is quite frankly something that is typical throughout the state, which is that municipalities are obligated to find ways to satisfy their affordable housing obligation. And they need to do so really despite what concerns they may have about the school districts and the capacity of that school district. It's just simply the very nature of this process that municipalities are really, in a sense, obligated to put on blinders to what some of these impacts may be, whether we're talking about school concerns or perhaps other large infrastructure concerns. Municipalities are furthermore not permitted to require developers pay impact fees to their schools. That is not something that New Jersey municipalities are able to put in place, such impact fees. And then I think those are all your questions. There's a recognition about the new special improvement district assessment as well. And that's sort of part of what a municipality is obligated to put blinders on. We're really not able to anticipate or consider those types of additional impacts. That said, I do want to highlight the fact that developers are going to be obligated to ensure that roads and sewer and water infrastructure is able to sustain their project. So for example, if they need a sewer line upgraded to their property in order to provide sewer, or if they are required to provide, let's say, road widening, just as a simple example, in order to provide safe access to their site. Developers are going to be obligated to do that. And that's something that a planning board, when they come in for site plan approval, that the planning board will address at that time.
I would just like to make note too that the other B3 zone in the township was not included in any overlay zone as well.
I have nothing to add to Beth's answers. Mine would have been the same for all of those. I think she accurately set forth what the law is with regard to those issues.
Okay. Mr. Volpicelli,
Good evening. Can you hear me?
we can.
Great. My question is around market to affordable programs. Other municipalities in the state have taken advantage of or used market to affordable conversions to meet a portion of their affordable housing obligation. And while it is maybe more money up front for a township to do that, it has the advantage of not growing the total housing pool and therefore putting less pressure on the school systems, which I think in our case are close to full, having rebounded 86% since the low in the 1990s. And so did we consider market to affordable housing as part of our negotiations? I think it would have been cheaper to do that than it's going to be to pay to expand our schools down the line. Thank you.
Market to affordable, it can be a really good program for some municipalities, but one of the things that's important to remember is that it's limited to just 10% of the obligation. So any municipality's ability to make use of that program, first, like before we even talk about some of the costs and the negotiations around it, the permitted use of it is rather limited for the municipality. So that's the first thing to know. The second thing to know is that it is a very rarely used program to meet the unmet need. I'm sure there's a municipality out there that's used it to meet its unmet need, but I can't think of one. So it's very rarely used. And that's done typically because the unmet need is intended to incentivize the production of inclusionary housing predominantly. And so that's why you see here in Milburn and most municipalities across the state, the dominant strategy to meet the unmet need, not the only strategy, but the dominant strategy is in fact inclusionary housing. And as part of, keeping that in mind, what's typical, and not only is that typical, but that's actually what's expressed directly in the affordable housing rules is overlay zoning. As part of that, we also have to keep in mind that the affordable housing strategies that we've gone through tonight to meet the RDP and also to meet the unmet need, it is not Milburn alone determining exactly how we should meet our obligation. These strategies are in our settlement agreement because it is a negotiation that Milburn had with Fair Share Housing Center. And so there are a variety of factors that need to be considered, not only from Township of Milburn, but also Fair Share Housing Center as they consider whether or not they'll enter into a settlement agreement with Milburn. And so that typical strategy, the strategy that's preferred across the state, is to utilize inclusionary housing. But then, like I said, to the extent that Milburn or any municipality could have used market to affordable, it really is limited to just 10% of the obligation, but it's further limited to that which a settlement partner, Fair Share Housing Center, will also agree to.
Thanks, Beth. Mr. Chase.
Hey, thanks, guys. Thanks for taking my question. I guess I have two questions. One regards the density amounts that are in each overlay zone. So I guess like the Annie Says property, I think the property or the project that's been approved there has a 68 dwelling units per acre. But that area in the overlay zone is approved for 40. And like the Wells Fargo, the project that's going in there is 35 dwelling units per acre. But that area in that overlay zone is approved for 25. So the projects that are going in are above the amount that is approved in the overlay. So I guess my question is, are the densities in the overlay zones sufficient to encourage development there? Because by my understanding, we need to get some significant progress towards development by 2025, or we'll start to be sued all over again. If you could comment on that issue.
I would love to take that. So I think we're in a little bit better, I think we're in let me be clear, much better position than I think your question suggests. So first, yes, we do have some overlap of where our overlay zones versus where some of our site-specific strategies are. And just, I know this wasn't your question, but just so we're all clear, municipalities, we are going to be obligated to utilize the site-specific zoning when those specific sites come in. So the Annie Says property will utilize the zoning specific to their site, and then the surrounding properties also in that overlay will use the overlay zoning. So I know that's not your specific question, but the broader question is, if our site-specific zoning has such an increased density compared to the overlay zoning, are we going to be okay? Are we going to be able to fulfill our obligation? Are we going to start getting sued? I think the answer is no, in the sense that no, we're not going to start getting sued, but yes, the density is adequate. So first, those densities came from extensive negotiations with Fair Share Housing Center to ensure that they were adequate. But one thing I want to emphasize is that those overlay zones are not required to be built out between now and the end of the third round, or between now and, which is June 30th, 2025. And in fact, I would say I have no expectation that they will be. I don't think Fair Share Housing Center has any expectation that they will be, and nor will the court have any expectation that they will be. So I do not expect to see come July 2025 site plan approvals on all, or perhaps even the majority of lots within your overlay districts, and that is okay. The municipality is not going to be sued because our unmet need has not been entirely fulfilled. There's, as I said at the outset, there is no expectation that one, the entire unmet need number will be fulfilled with affordable housing. And let me also say there's no expectation that our unmet needs zones will be entirely redeveloped or subject to site plan approvals by the end of the third round. And that's okay. That's typical for vacant land communities across the state, not even just including Essex County.
Thanks, Beth. Come on,
Hi, can you hear me?
we can.
Hi, thanks. So first, thanks for providing us the opportunity to ask these questions. It's really appreciated. I have, I think, two questions. One is, what is the total number of housing units that will be added as per this plan? As per the consensus 2020, we have total around 4,325 housing units in short hills as of today. And if I just do the total, then I think the total is running that we are proposing as under this agreement to add almost 1,000+ units. So first question is, what is the total number of units that we plan to add? And second is given that we are planning to add 25% housing unit of the existing stock that we have in our area, I think it behooves us that we do all this kind of analysis on how would it impact the traffic, how would it impact schools, because overall it is not a small change. It's a big change, and we should all look into all the aspects of the lives that will be impacted because of this change. And second question I have is do the town and the residents still has any probability of raising their voice if they don't agree with the current plan? And how do they go about raising that voice and seeking some help?
Thank you. So I just want to touch on the beginning of that that question, because the Township of Milburn actually has 6,277 housing units in totality. You know, obviously there are 2 zip codes in the Township of Milburn, and you may be splitting up the number of housing units in both those zip codes, but the township as a whole has 6,277 single family housing units. So, and then I think Beth can speak more to in terms of what is actually being built and what we had described earlier as what is, you know, what we're creating a realistic opportunity to potentially be developed, but is not necessarily being developed. So
what's definitely going to be developed in the township between now and the end of the third round? That question is very difficult to know. I'm not trying to be funny about this, but I would really need a crystal ball in order to give an accurate answer. What I can say is what I expect to be developed, and that is I expect that the municipality is going to fulfill its RDP of 114 units, and that's composed of 80 units, affordable units that will be developed, plus existing group homes and plus bonus credits. All 3 of those components, the 80 units plus bonus credits plus group homes, gets us to a compliant 114 unit RDP. So that's just 80 homes. Beyond that, I think we can expect that the 75 units of 100% affordable housing will be developed in the township. Beyond that, we know that the Woodmont property site will seek development approvals, and that's going to be another 39 affordable housing units that they'll seek approval of. And that's a total of 194 affordable housing units. Those are the only affordable units that I feel very, very confident will seek approval and may actually begin construction, perhaps even complete construction by the end of the third round. The rest of the units in the township's plan are subject to those overlay zones. And I suspect that some property owners will come in and will seek site plan approval for redevelopments of inclusionary housing within those overlay zones. But I really can't predict which properties or how large those properties might be, and therefore what number of housing units may be developed on those properties. Your second question was, is there really an opportunity for township residents to speak out against the plan? And there are several opportunities for public input that's coming. We have there's the fairness hearing. We also have the housing element and fair share plan public hearing. And of course, when applications come before the planning board for site plan and for site plan approval, as well as when ordinances implementing these sites go before the governing body for their public hearing, each of those creates an opportunity for public comment and input, as well as questions.
Thank you, Beth. Ms. Pasternak.
Hi, I was confused by your note, Alex. I'm sorry, but there are questions there that I didn't write, so I'm not sure how they got there. Anyway, I have a whole bunch of questions, so I'm just going to try and go ahead. I'm Jean Pasternak, 342 Hobart. I just wanted to know that when did Milburn direct its council to begin preparation of the declaratory judgment? And I'd like to also know, what protections do the overlay zones provide to the adjoining residential homes? A little bit more on what probably was already somewhat asked, but what is the town getting in return for optimizing the number of market rate units in the settlement agreement? The infrastructure costs will be pretty enormous. It looks like the taxpayers are going to bear a lot of this cost. There was no study done on the school expansion, but we do have police, fire, all sorts of different things that would be required to support a vast increase in our population. So what you sort of referred, Ms. McManus, to other towns, kind of this is typical and they deal with it, but I really didn't get a clear understanding of what the response is about our town to that. Also, why do we refer to the sites like sort of in a mixed up way? Some are referred to by the names of the developers, some by the old names of the properties, like Annie says. Can we be consistent on that so that the community is aware of who these developers are, you know, what exactly projects they're working on, in case they would like to direct questions to them? Was there an attempt, it seemed like the declaratory judgment was submitted late. Was there an attempt to slow walk that, and why? And let's see, there was a statement made by Ms. McManus that the overlays exclude residential districts, but most of the stuff is being done right next to the residential district. So I'm not sure that was exactly a fair statement. As far as the donation, the 85,000 to the fair share housing, other towns that I've seen, referred to, their donations were much smaller than this. And I'm looking at that in addition to the fines that are in the agreement. It seems like we're being penalized because we're Milburn. I'm not sure. I just have a question about it. The other thing, I guess a couple other things I would like to understand. When was the settlement agreement reached, like the actual date that it was reached? And did anything change between the July 30th vote and the August vote? When did the court issue the order that they could not disclose the terms? Because that seems to be a really misunderstood, or we just don't understand why and who said that the residents and the taxpayers could have no input into the agreement. it seemed to be stated that the judge said that. Is that the case? And when was that done? Was there an order? Was it in writing? I think it would really help us to build some trust to understand exactly what happened. As far as the agreement, after the agreement was reached, but not yet voted on, was the court ever asked if the town could make the terms public? And that's sort of more specific question on what I just said. And what was the July 30th email from the court about? What happened in the time frame that caused that problem? Why is Annie Says and Woodmont part of the fair share agreement? Why did the town hire the 3 different law firms? And who made the decision to do that? And who made the decision to oppose Woodmont in the first place? Were rooftop decks part of the mediation? And if not, why not? Who made the decision to submit the original numbers contained in the complaint? Why did it take?
Ms. Pasternak, I know you just rattled off about 20 questions.
That's it.
Sir, okay, if that was it, fine. We want to make sure that we can, one, remember all of them and get back to them, but certainly there will probably be some additional time if you wanted to come back and ask another question or finish up your list. But let us get to these and see if we can't answer some of them. Thank you. All right. Beth, you want to take an initial stab?
All right, yes. I think some of these are definitely in Ed's territory, Mr. Buzak's territory, but let me see what I can do. Let's see. There's questions about the timing of the declaratory judgment. I'm going to defer that to Mr. Buzak. What protections are in the overlay zones for adjacent residences? And I think there was also some concern that while the overlay zones, I had presented them as excluding a residential zone district so as to limit the impact. Is that really, there seems to be a concern given that the overlay zones are adjacent to residential homes. That's a fair question. So in terms of what protections for adjacent residential districts for those overlay zones. So the first thing to understand about this is the overlay zones have not yet been crafted. So the ordinances just simply have not yet been written. And so I can't tell you specifically that overlay zone 1 will have a buffer requirement of X or will require this to be sensitive to the adjacent residential districts. That's simply language that hasn't yet been put together. I can say that the intent is to limit the impact to the extent possible, given the densities that we're obligated to allow. But the intent is going to be to limit the impact on the adjacent residential neighborhoods. That goal is going to be at the front of everybody's minds, at every professional you see here, as well as at the front of the governing body, as well as the planning board's minds as they review these ordinances. I do want to remind folks that when those ordinances are being developed and adopted, they do have to go through a public hearing process. And so I'm sorry, I can't give a specific answer on these now, but I will say, keep an eye out for meeting agendas, because each of those ordinances will have to go before the governing body for a public hearing. And I'm sure they'll be interested in hearing resident comments and questions on that topic. There was also a question about what the township is getting in return for optimizing the market rate units. I'm sorry if I got that question, if I jotted it down wrong, but I'm not sure I understand what that means, how to answer that question. And how do other municipalities deal with the various impacts, whether we're talking about schools or police officers, et cetera? What municipalities do, I'm sorry to say, it really varies by municipality. It's going to vary based on the extent of strategies, the extent of new zoning and new housing that has to be developed as a result of meeting their obligation. Perhaps municipalities already had a bank of excess affordable housing units that they could draw upon to meet that third round obligation, or perhaps their obligation was smaller or larger. And so their strategies to address that impact is going to have to be sized and scaled appropriately for that town. Municipalities have done taken a variety of actions to address that impact as they saw fit, in specific for their municipalities. it's a good point about the varying names for the different developments. That's something that we can keep in mind moving forward so that folks are clear about what each site is and where it's located. Let's see. There are questions in there in regards to the penalties and the in the structure of that settlement agreement. I think I'm going to defer that to Mr. Buzak as well. As well as questions in regard to public input that was permitted during the negotiation process. And as well as the court's direction at the end of July 30th. There was another question about why the Annie says in the Woodmont. I have written the Woodmonts. I sort of thought you said Wells Fargo in my head, but why these sites, Woodmont sites, are included in the settlement agreement. Those two developers had a seat at the table, and ultimately, in order to reach a global settlement, in order to reach a settlement with Fair Share Housing Center, that's sometimes what is referred to as a global settlement, the municipality was obligated to include these sites in its housing plan. Fair Share Housing Center typically seeks to make use of affordable housing resources it sees within the community. In this example, our affordable housing resources were two properties with development options for land within the township. And two developers, importantly, that stood there and stated their readiness and their willingness to construct inclusionary housing that included a 20% set aside. And as a result, those are two sites that the municipality that we were required to include in our settlement agreement with Fair Share Housing Center if we were going to settle with them. And it was really critical that we settled with Fair Share Housing Center in order to avoid builder's remedy litigation. Let's see. And then the last question I'm going to field before I defer everything else to Mr. Buzak is whether rooftop decks were included in as a topic in mediation. And I'm sorry to say, I really can't reveal the details of mediation during a public forum. That's just simply not permitted to do so. So with that, I think that's everything I can address.
Just real quick,
Alex,
sorry, Ed, just real
Oh,
quick
go
on
ahead.
the
Yeah, if I missed
topic
something, please.
of police, fire, different things like that. I think we also need to understand that as developments come on and that, that population increase may happen, but these are also ratables that are going to be injected into the township, which will increase the equalized valuation of the town, which in turn can, increase the amount of, tax revenue coming into the municipality, which may not necessarily be 100% of the answer, but certainly does have benefit. Also, we have a sewer connection fee that helps, adjust for, any sewer capacity issues, which at this time with the municipality is not necessarily a concern or an issue, but that does not mean it won't be in the future. But I just wanted to point that out because I think sometimes we forget as these developments do come on that they are ratables. I know that there's varying opinions on them, but they do and will pay taxes in the municipality, and that none of these current developments, Andy says, Woodmont, Wells Fargo, Silverman, none of them are piloted developments. Sorry,
If I
go
can-
ahead.
I don't want to cut you off, Ed. I know everybody's waiting for your response, but just to supplement Beth's comments regarding zoning and the overlays and proximity to adjacent districts, and impacts on adjacent residential. It's important to remember that the overlay districts are supplemental regulations over top of existing regulations. So the existing B2 zone, for example, and the CMO zone do already have stipulated setbacks, from adjacent properties. There's even specific language within the existing code about setbacks from adjoining residential districts that, increase requirements or those things. As Beth did mention, the overlay districts that the township will craft can provide even further buffering requirements or supplemental buffering requirements. But it's important to remember that the process that will be followed as we move forward in the development review It's going to be the same as any development process for individual sites. This will be an application for site plan approval to the planning board. There'll be a public process to participate, and the board will be empowered to evaluate unique circumstances for each property and impose conditions that may help alleviate any adjacency concerns or impacts. So it's important to remember that process will remain in place as well. So I'll kick it over to you, Ed.
Okay, thank you. Picking up on Alex's comment with regard to the question on infrastructure impacts, police, fire, other services that the municipality would provide. I think Alex's point is well taken. And you will also recall that Beth had mentioned earlier, and I will re-emphasize the point that this constitutional affordable housing obligation that I referred to at the outset is independent of all these other factors. And her answer earlier to the question about were impacts determined in terms of traffic, in terms of schools, in terms of infrastructure. The answer is that none of those factors are brought into play in terms of satisfying the obligation that you have, constitutional obligation. So the municipality was not derelict in not considering those things. The fact is that neither the courts, the special masters or the courts, nor the law allows that at this time to be considered. With respect to when the DJ action was authorized, I can't give you a date because I don't remember. The prerequisite to filing the declaratory judgment action was the adoption of the Housing Element Fair Share Plan. And the prerequisite to the adoption of the Housing Element Fair Share Plan is the preparation of the Housing Element Fair Share Plan. And that Housing Element Fair Share Plan that was prepared included a vacant land analysis to adjust the obligation that the township had based upon the fact that we had insufficient vacant land. So that was started, I believe, in 2017 at some point. I can't tell you any given date. It was finalized sometime in January or February. I think it was February of 2018. The planning board actually had a public hearing scheduled. I believe it was February or it could have been March of 2018. And that hearing was postponed as a result of a snowstorm or some inclement weather. I can't remember exactly what it was. And we had to carry it to the next meeting. As soon as the Housing Element Fair Share Plan was adopted by the planning board, within a very short period of time, and it could well have been days as opposed to a week or two, the township endorsed it by resolution, and the declaratory judgment action was filed as soon as that was done, because all of those had to be done as a prerequisite to the filing of the declaratory judgment action, which I recall was filed in April of 2018. The attorney's fees section, I have nothing more to add to what I've already said about that. It is true that the attorney's fees amounts vary depending upon the municipality, depending upon the efforts that were put in, and a whole variety of other factors. I can tell you that I'm aware, and I suspect Beth may be aware as well, of other settlements with Fair Share in which the fees were higher than these numbers. So I can comment no further on that. Question was asked as to when the settlement terms were reached, and those settlement terms were reached late morning or early afternoon on Friday, July 30th, 2021. That was the date that the township committee had convened a 10 a.m. meeting to consider the settlement agreement. At that time, the settlement agreement still had not been finalized. And during the course of those several hours between the start of that meeting and the end of the meeting, it was finalized and it was approved. Question was asked whether there were any changes in the settlement agreement between the one that was approved on July 30th and the one that was reapproved in August 17th, I believe it was, of 2021. The answer is no, there were no changes between those two dates. Beth's answer with regard to why Woodmont, and then he says, were sites that were considered and ultimately included is accurate. I have nothing to add to that, except that when she said that they had a seat at the table, you should be aware that each of those properties applied for intervention status. They attempted to be intervened. First Woodmont on 2 or 3 occasions, actually. And Judge Gardner denied, we opposed their intervention. Judge Gardner denied their intervention, but as accurately set forth by Ms. McManus, they were given a seat at the table. The difference between the two is almost similar, although not exactly the same as the difference between the builder's remedy and non-builder's remedy. The fact they were given a seat at the table meant that they're able to participate, but they don't necessarily get any one-upsmanship. But as Beth pointed out, when you're in a land poor municipality where we're seeking a vacant land adjustment, any property owner, whether they have a seat at the table or they just come in and start waving their property in front of you, until the case is settled, those properties become properties of interest, so to speak, so like persons of interest in investigations, because you're saying you don't have any land and therefore your obligation should be adjusted. And all of a sudden, a property owner or contract purchaser of property comes in and says, wait, I have land available. Obviously, that undermines the position and is inconsistent with the position that you don't have any land, because now land that you did not assume was available has now become available. And until a settlement is actually reached and the signatures are put on the settlement agreement, that risk is always out there. And in a municipality that's seeking a vacant land analysis. The fine, you mentioned the fines in the agreement. All I can point out is that the fines dealt with the dates for adoption of the implementing ordinances. Those dates were fulfilled either on the dates as required or on dates that were extended as requested by those property owners who were not ready to provide us with the information, particularly provide Beth with the information that she needed to draft the ordinances. But that the time periods within which the township was required to act were fulfilled. There are no penalties that have been implemented under that settlement agreement. As to the confidentiality issue, which I know has been one that I've heard now for years, both the mediator, Frank Banish, had determined, and we had all determined during the course of mediation, as mediation is typically conducted, all of those discussions are confidential. And they remain confidential until the result of that mediation is achieved. In our case, it was the settlement agreement itself was achieved. Until the time that it was signed by all parties, we did not have an agreement. And the only reason that Beth was able to discuss the agreement at the August meeting was that by that time, and it was, I think, just before the start of the meeting or a few hours before the start of the meeting, we had gotten signed copies of the agreement by the other parties. So we knew that they were bound as soon as we approved that agreement, and we now had a binding agreement. Getting back to the issue of, can we back out of the agreement? Once that agreement was signed by everybody, it now established legal obligations on everybody's part as to what they were going to do, which then allowed Beth to be able to disclose where we were. If somebody did not sign that agreement and we went back, negotiations would be compromised when positions of parties are now put out there before there's a final settlement agreement. That's the way mediation works, and that's why it worked in this case. I think I have all the items, Alex, that I could cover under the questions that I jotted down. And you said there were a lot that were being fired out there. If you have any others, Alex, that either Beth or I missed or Graham missed, please let us know. And we'll
No, I think that was sufficient by everyone, and so I'm going to move on. I think we have one more individual that has not spoken yet, and then there's a couple that just had their hand up again. All right, Mr. Feld. Mr. Feld? All right, we'll keep your hand raised. We'll come back to you. I'm just gonna ask that BH put a name with, if you can, so that we can call on you. Let me go to Ms. Urso. Or Mr. Urso.
Oh, there we go. I hit the wrong button.
Okay.
Hi, thank you for, we're both, my husband and I, we're actually together and we both have some questions. So getting back to the B3 and your negotiations that Ms. McManus said, developers had a seat at the table. Why wasn't it inclusive that not only developers have a seat at the table, the residents should have had a seat at the table, because ultimately it's going to affect the residents. Other property owners didn't have the opportunity to have a seat at the table. And, you know, it's true what they say, right? The rich keeps getting richer, the poor keep getting poorer. And you're putting the burden and saddling us with debt and taxes and infrastructure and the schools. So if you can clarify that. You also said that, you know, you did answer that there was no school study. What other studies were performed to help negotiate your negotiations, or, you know, come up to your, you know, what other studies were performed or not performed? We closely looked at your overlays. I know all of the properties. I know all of the property owners, and I know the players. And again, we own 5 properties in the B3 zone, and we were excluded, not even entertained conversation, or if we would even consider brought into the negotiations. It's like you just jumped right over one zone. You know, I know that we're all, you know, in different positions, but, you know, this town seems to be that it's very non-inclusive. You know, it's you got to do for all. I mean, if there's other people, you know, you're only catering to a certain pocketbook. I don't see that, you know, it's very you know, you're non-inclusive. You know, I might not be in the same caliber as these multimillionaires, but they were brought to the table and we were not. We were left out. Why is that? It's concerning. This town has not been nothing but non-inclusive. You know, you have 4 zones and you're not including all of, I mean, there's other property owners in the B3 zone that I know that you've also excluded. Why is that?
Okay, Mr. Urso, I think we've received your question in terms of why was the B3 zone excluded from the settlement.
And so when would I be privy to getting these private conversations? I mean, this should be public record. The town should know, people should know, property owners should know.
I think we'll.
The residents should know
We'll attempt to
why
address
some
your
and not
question now.
another.
Thank you, Ms. Urso. Okay, I think first and foremost that, you know, just to clarify that, as I had stated before, there are other zones and zoning districts within the municipality that were not included in overlays or in negotiations, including OR2, B3, both B3 zones. And I think that the B1s, all of those things were not included in these negotiations. But I also want to be clear that the individual developers that were, quote, an interested party or had some seat at the table were those that had petitioned to the court to do so. And certainly anybody on this panel can expound on that, but I just wanted to touch on that.
Alex, let me, if I can, I'll start and then I can pass it to others. Just following up on your last comment, that is the answer. The developers participated in the legal process. The court ordered what they ordered or what the court ordered, and that's why they had a seat at the table, different from being an intervener, which would have given them even greater rights than they had. I want to touch on, Beth may be able to expand what I said. The question was asked, what studies were done to sort of prepare for negotiations and prepare this? And it's important to emphasize the process that I went through earlier. This process was initiated by the township. The township made all of the decisions to move forward in a certain direction. And all of those decisions before the declaratory judgment action was filed resulted in the Housing Element and Fair Share Plan, which is the basic roadmap and proposal of the township as to what their obligation is and how they're going to satisfy their obligation. As was pointed out, that Housing Element and Fair Share Plan was a public document, was a public document back then, and was subject to a public hearing. It was available to the public. It was generated as a result of months and months of work by the planners for the township at that time, looking at every single parcel of property within the township of Milburn, categorizing them as the vacant and non-vacant, then looking at the vacant lands and going through that whole analysis, which I won't go through, and Beth's gone through it herself in other occasions. It's a tedious, comprehensive, lengthy, and informative process. The vacant land was identified. The appropriate formulas were applied to those to result in the Housing Element and Fair Share Plan, indicating that while the township's obligation may be greater on paper, the available land limited the township's obligation to a number. And in fact, if you look at the original Housing Element and Fair Share Plan, or the Housing Element and Fair Share Plan, because a new one has not as yet been prepared, you'll see that the vacant land analysis determined that the township's affordable housing obligation was less than 114 units. And therefore, the township's plan to satisfy their obligation as set forth in that Housing Element and Fair Share Plan in detail, including how unmet need was going to be satisfied, was different from where we are now. That's not unusual because this is the township's, when it was originally prepared, that's the township's position as to how it should be, and what their obligation is, how it should be satisfied, how the vacant land should be adjusted, and so forth. Once that lawsuit is filed, then all of that is subject to scrutiny. That scrutiny is in the form of Fair Share Housing Center looking at that analysis and challenging it. We spent months and months dealing with issues related to that housing on fair share plan and the vacant land analysis. And ultimately results in the settlement that you see. So I think it's unfair to characterize or at least imply that the township was not prepared. The township was very prepared and had a plan going forward, which it had to have, and it's the only way to obviously proceed in these kinds of cases. The township had all of that. That ultimately, though, is not the way any of these things come out, whether it's in litigation, whether it's in other negotiations with regard to other subject matters. People put their best foot forward, so to speak, and then they attempt to resolve things. And the compromises that are made, as I've said, and I'm sure many people have heard, if a settlement is ultimately reached and nobody's happy, it's probably a good settlement. If one side is really happy, it's probably a very bad settlement. And I dare say that in this case, no one is happy, but that's the sign of a good settlement. That's it. That's my share of the answers. I'll pass it to either Beth or Graham or Alex, you, if you have anything to add.
I have nothing to add. Thanks, Ed. Beijing.
Hi, I assume everybody can hear me.
We can.
Okay, great. So everybody's first question is that Beijing He, and I am on 290 Taylor Road South. Thank you for taking my question. I have 3 questions. Number 1 question is directed at Beth. I think 2 earlier questions were about utilizing the existing apartments to satisfy affordable housing. And I think your answer is it's not being utilized because it's not very efficient. And you keep quoting the 10%. I just want to understand, what does it mean? Does it mean if the township buy an existing apartment complex that has 100 units, only 10%, only 10 units can be used to satisfy affordable housing? So that's question number 1. Question number 2 is, I guess just for my understanding, how does an affordable unit stay affordable? I mean, the developers say, we're developing 30 units and 20% is going to be affordable. 10 years down the road, are they still obligated to keep those units affordable? And does the township will continue to use that 10 unit affordable units forever and ever? How does that all work? And my last question is the overlay zones. To your knowledge, have there been any applications to utilize this overlay zones? Thank you very much.
Thank you.
Okay, I'm going to kick things off, but I can tell I'm going to defer the overlay question to Graham or Ed. But the first question was for clarification on that 10% I figured for the market to figure I cited for the market to affordable program. So it's 10% of the obligation. It's not 10% of units that might be purchased. So let's say we're thinking about the RDP just as an example. So that's 114 units. So 10% of that is around 11 units or so. So that's how that 10% calculation is done. The next question was, how do the units stay affordable? That's a great question. And that is, that mechanism is through a deed restriction. That's the case for almost every type of affordable housing that we talk about, and specifically the ones that we're talking about here, whether it's for your overlay zones or your RDP sites. Each of those affordable housing units is going to be subject to a deed restriction. So a document that's attached to the deed that states, for not less than 30 years, the units shall be reserved for low or moderate income households. And that means that if you, let's say you're a low-income household that purchases a unit at that low-income price, that means that when you sell the unit, let's say 10 years later, that instead of selling it at market value and getting a windfall, you are obligated then to sell it to another income qualified household at the restricted price. So if you're a low-income household selling your low-income unit 10 years later, that means you have to sell it to another low-income household. And so that's how the units are maintained, if you will, for a period of at least 30 years. It's done through a deed restriction. And so the last question was, have there been any applications for overlay zones? I'm going to defer to the two professionals here that work with the planning board on that.
Well, I can get started. So, as I mentioned in review of the sites that we had discussed, the two overlay zones have been adopted by the Township Committee. The overlay zone for the Woodmont property and the overlay zone for the Annie Says property have been adopted by ordinance. The remaining overlay zones have not yet been adopted. So no development application can be filed under those parameters because the overlay zones have not yet been codified into Township code. So those will be forthcoming. And as we discussed earlier, there is a public process for ordinance adoption. The ordinance is introduced at the Township Committee. It's referred to the Planning Board to conduct a master plan consistency review, at which there is opportunity for the public to hear that. And then also then there's a final public hearing on adoption of the ordinance back at the Township Committee, where they have the benefit of reviewing and hearing the Planning Board's comments on the consistency of the proposed overlay zone. So there is a public process to engage in that part of it. Following adoption of the overlay zones, that's when any development consistent with the parameters set forth could be filed and come through for development. And as I mentioned earlier, the development process will remain the same. Any development application to develop any of these sites within these overlay zone areas will proceed to the Planning Board for jurisdiction review. And at that time, that will be a public hearing process as well, where the public can comment and make recommendations or suggestions with respect to the proposed development style at that time. Ed, if you want to add any more on that, you're welcome to chime in.
Just a couple of items. Number one, the Annie Says zoning is not overlay zone. That is underlying zoning that has been adopted. It's effective subject to the approval of the settlement agreement. So until the settlement agreement is approved by the court, it will not be effective. Graham correctly pointed out that the overlay zoning for Woodmont has been adopted. That has a couple of added conditions related to its effective date. The important one related to the fact that before that property can be developed, it needs to obtain an exemption from the Watershed Property Review Board, which is a state agency, because that property is subject to a legislative moratorium on disposition. It's owned by a water company. Back in the late 80s, as I recall, or early 90s, the Moratorium Act was adopted by the legislature because water purveyors were selling off watershed land for development and in a way to stabilize their rates and so forth. The legislature adopted a moratorium preventing the disposition of any watershed property and provided also a safety valve or a process to allow, in some cases, the disposition of or the sale of watershed property in certain situations. That process is one that is administered through the Watershed Property Review Board. So neither of those properties can today file applications before the planning board. The Annie Says property, assuming that the settlement agreement is approved at the fairness hearing, tentatively may be able to file after the final judgment is entered. I'm not sure they'd be able to file before that, but that's something we have to look into. That's all I have to add. Thank you.
Thanks, Ed. Thanks, Graham. Mr. Chase, you had a follow-up?
Yes, thanks. Tom Chase of 6 Clinton Place. So yeah, I wanted to ask a follow-up question about the issue of multi-use of the properties, whether there can be a commercial component in addition to the residential component. Obviously, I think most developers in the areas that are overlay zones that are busy sort of commercial or corridors would love to put a first floor of commercial properties in, and then have residential properties above that. And maybe residents in the area would prefer that there be a commercial area as well. I don't know how that issue stands now. Is there any commercial component that's allowed in the overlay zones? And if not, when is that issue decided? Can there be commercial properties allowed by statute or by zoning, or is it a variance issue? Can you just comment on that? I know, like for Annie Says, I think Annie Says does have multi-use permission, right? So if you could just discuss like how multi-use is incorporated into the overlay zones.
Okay, so I think I can start that. So for the overlay zones, whether they'll be, well, actually, let me back up for a moment. So one, the existing commercial zoning in those overlay zone areas, so the underlying B2 or CMO district zoning, whatever the case may be, that zoning will remain in place. And so property owners will continue to have access to that zoning, if you will. So if it permits a freestanding retail store today, it will continue to permit that tomorrow. So just so we're clear on that. But for the overlay zoning, will that allow for mixed use? So that's one of the decisions that the township hasn't yet made. So the municipality has the ability to incorporate mixed use into these overlay zones, but it has to do so in a way that continues to allow for that residential development. So for example, if we look at, say, the B4 district, which has a density of 25 units an acre, the municipality can permit mixed use as part of the overlay zoning, but it has to ensure that the residential development at 25 units an acre can still be developed along with the mixed use. So for example, this is a very overly simplistic example, but if the building height is set at, let's say, 3 stories, just for an example, for all residential development, in order to achieve that 25 units an acre with a first floor retail use, the township is going to have to consider whether or not it needs to, for example, increase the building height. So it allows for that 25 units an acre plus the commercial development. So I've used that example to try to highlight that this is a tricky issue that requires a lot of consideration. Not only do we need to put in place the zoning that sets all of the site and the building parameters, but as part of that discussion, as part of that thinking, the township will also be considering if and where it wants to permit mixed use and what flexibility it needs to add into that zoning in order to accommodate not only the required residential development, but that plus the commercial development. So that was a long-winded answer. The short answer is maybe. That's something that's going to be considered as part of developing each individual overlay zoning ordinance. And it is something that's going to be subject to the public hearing and a topic that'll be available for questions and comments at the public hearing when the municipality goes forward and adopts each of those overlay zones.
Yeah, and just to supplement, that's a good answer on that. There are the overlay zone does overlay in some districts in which we may not see residential development be compatible with the underlying permitted uses, such as the CMO zone permits light manufacturing. That may not be an adjacent use that we want to have with a residential use. So the overlay zone could further stipulate parameters as far as how the residential use may be in concert with the underlying permitted uses as well. So there'll be some further development on that to be aware of as the township moves forward to ensure that it's crafted in a sensible way.
Yeah, that's a great point. Thank you very much, Graham. Right, some places might be better suited for mixed use than others.
Thank you. CBC, please identify yourself.
Alex, this is Kerry Heller.
All right, thank you.
I'm sorry, I should have been CBH. Sorry.
Yeah.
Hi, I have procedural questions, but we'll leave those for another day. I have something more substantive I'd like to both ask and say. One, I think we've pushed this down the road, much too long, too far, and that's why we're having this very severe discussion now that prior TCs didn't comply. That's for another day. I do have questions. At the time of the settlement, just to clarify what Beth and Ed said, literally at the day, the moment, the time of settlement, did we still have immunity sitting at the table that day? That's question one.
Okay.
Regarding 11 Main Street, I know we're not going to talk specifically about that, but the word inclusionary has many definitions. Inclusionary in the town or inclusionary as part of a larger project. People around town certainly know that I think that what we did there to the DPW was not correct. Tucking that project into the along the railroad tracks on Main Street, certainly not inclusionary. I would call it more exclusionary. I'd like to know just why that was done without the context of the larger DPW and the vision and plan for the town. Three, just an easy question. Haven't heard, I read a lot, I'm in a lot of other towns, just listening to these discussions and negotiations. Are fair share housing projects eligible for a pilot? Just fourth question, if you could explain a little bit more in detail what's going to happen in 2025 for those who don't know in terms of the next round of negotiations and what that's going to be predicated upon. The Annie Says property has about 70 units per acre. My concern there, and gentleman who just asked the question, and you say something may or can continue with commercial, that particular piece of property, I don't believe has any commercial included in it. That's one of my questions, is why as part of our negotiations that we're separating the B4 zone and the B2 zone, the property known as the Commons, and you go and put a residential property without any streetscape on that first floor, we lose the SID dollars, we lose potential walkability as we try to discuss two-way traffic on Milburn Avenue. Again, I understand the pilot, I'm sorry, not the pilot, but the fair share housing obligation, but why did we have to give up the commercial? And I want to make sure that we understand commercial versus necessarily retail. We're losing a commercial opportunity there. Last, if I heard correctly, what you just described on zoning for commercial or residential in any unmet zone need, or let's go for the moment to B4. I thought I heard you say that by example, I own the Starbucks corner or the movie theater across the street, that we could change our first floor use by our choice to not maintain a retail or commercial presence or office presence on the first floor. I just want to make sure that both for existing buildings is one question, and for any of the new projects, again, if you're in the middle of a block in the B3 on Upper Milburn Avenue on Morris Turnpike, that we shouldn't just be making residential properties on first floor streetscape. Thank you.
Thank you, Kerry.
Alex, I'll start with a couple of those things and then I'll pass it to Beth and Graham.
Okay.
In regards to the immunity issue, yes, the township had immunity at the time the settlement was approved on July 30, 2021, and maintained that immunity through August 17th, 2021, when it was reapproved, and continues to have immunity up to the fairness hearing at which time it will be addressed then. I'd love to be able to answer what happens in 2025, but I'm going to pass it to those who have greater knowledge than I. So I'm going to pass that one to Beth and Graham, and I'm sure they're delighted that I've done that. I'll try to I'll take a stab at the overlay zoning issue but I will defer to Graham and Beth. I may not have understood it correctly, but if in fact overlay zoning is put in place in the B4 zone and it allows X number of units per acre of residential development, I would think, and again, I'll defer to both planners here. I would think that any property owner within that zone could take advantage of that overlay zoning. It doesn't have to be a vacant site. It doesn't have, they don't have to demolish what's there. So theoretically, a non-residential project would be able to be changed to a residential project if it conformed with the overlay zoning. So Starbucks doesn't have to be maintained there. You can change that to a residential if that in fact is part of the overlay zone, and you can meet the overlay zoning requirements for the number of units per acre that we're talking about. That's all I can touch on. But I'm really interested in the answer more than Carrie Heller is about what happens in 2025. So thank you for asking that question.
If I had a definitive answer about what happens in 2025. I think all of us that work in this industry, I think we all wish we knew exactly what was going to happen. But right now, I think the best I can say is unless the legislature, our New Jersey legislature takes action and perhaps amends the Fair Housing Act, or perhaps the governor gets COA back in action, essentially, ensures that the agency is functioning to do this particular aspect of its job, which is to create affordable housing obligations, rules, and then to review housing elements of fair share plans, which is what they're supposed to do. Unless that happens between now and 2025, I think that we're going to be going through a similar process then, which is municipalities apply to the court, we work out our obligation with the court, perhaps with Fair Share Housing Center all over again, and we have our housing elements reviewed and approved. I'd like to think that the process will be a bit more simplistic and move a bit quicker, because now most municipalities have been through this process once, and we know what to do. We know how to do this much more efficiently than we were all guessing in 2015. But that's the best I can say. We really need action on the Fair Housing Act or the governor's office to get COA back in action if we want to avoid this in 2025. I concur with Ed's answer in regards to what happens with the overlay zones. There was a question about whether affordable housing projects are eligible for a pilot. The answer is potentially. 100% affordable housing projects are eligible for a pilot, and any project that's within a redevelopment designation is eligible for a pilot. And so if an inclusionary housing project is within a redevelopment designation, then it's eligible for a pilot. But let me be very clear, just because you are eligible for a pilot based on state law does not mean that the municipality is obligated to provide that pilot. That is a decision that each municipality makes on a case-by-case basis. There was another question about why 100% affordable housing on the DPW property. We really can't get into the details of that, but I do want to just state generally that the purpose of 100% affordable housing projects, rather the purpose of municipalities incorporating these projects into their settlement agreements, typically, not always, but typically, is because it's a way to get more bang for your buck, so to speak. Bang meaning, more affordable housing, and to do so with less density. So if you're doing a 75 unit project, that means that in order to create those affordable housing projects, affordable housing units, you're only having those 75 affordable housing units built. You're not doing the 75 affordable units plus all of the market rate housing that might go along with it, assuming there might be that 75 units is only part of a 20% set aside, or maybe in some other cases, even a 15% set aside. So you're getting more bang for your buck, more affordable housing with less development. And so that's a calculation that every municipality, including Milburn, does when they think about how to meet that affordable housing obligation. I think those are all the answers to the questions, but maybe folks want to add something else.
I just wanted to just underscore, I know we've talked a lot about the overlay zoning. And the example that the questioner had was a good one. I think it's important for everyone to remember that the underlying zoning remains in place and the overlay rests on top of the existing zoning. So in the example that was discussed in the B4 zone, for example, residential is a permitted principal use within the B4 district, but not on the first floor. So it's important to remember that, an overlay zone will stipulate density modifications per the settlement agreement. It may wind up permitting residential as a first floor use, but those are things that are going to be contemplated as the overlays are drafted and brought forward for implementation. So it's important to remember, though, that at its root, all the existing zones at their base level remain in place, and then there is also remains the consistency issue with the master plan. I mean, our master plan and the downtown vision plan recommend vibrant, active first floor spaces. So that'll be an important consideration as any new ordinance revisions are brought forward. Thanks.
All right, so we're running up right now against the end of the evening. So I would just like to kind of take this opportunity to wrap up and see if there's anything additional from any of the panelists that they would like to speak to. But mostly I would like to encourage everyone to continue to follow this. We have a part of our website that will be updated not only with this video, but also with additional information. And at times additional frequently asked questions as we receive them, or, and again, as we've heard some tonight, we may be adding to that as well. For those who didn't get to ask a question or wanted to ask a question or wanted to provide some additional input, encourage you to just email us at letusknow@milburntwp.org. And again, just anybody from the panel that would like to say anything further, we can certainly take the time now.
I have nothing to add, Alex. I appreciate the time of the other professionals here and you, and the public. Questions were questions, and hopefully the answers adequately address their questions. Thanks, Alex.
And again, yeah, thank you very much to the residents and to the public who have participated tonight and asked good questions and provided some material and education and knowledge to others, as well as an understanding of the process. And certainly we want to keep the lines of communication open. So please email us and we'll continue, and please visit the website so that we can continue to disseminate that information. So with that, and I'm just checking but with that, we will close the evening, and thank you all. Have a good night.
Yeah.
Thank you.
You guys can get, I just want to capture a couple more questions that come up on the Q&A. So I'm just going to stay on until everybody gets off.
Very good. Good night, everybody.
Thanks, Alex. Good night, everybody. Have a good
Bye-bye.
night.